Hey.
Prayer. Almighty God, in your wisdom and goodness have appointed the offices of leaders and county assemblies for the welfare of society and the just government of the people. Was in line with Article 181 of the Constitution of Kenya, 2010, Section 33, subsection 1, and 9A of the County Government Act 2012. And Standing Order 71 and 72 of the County Assembly of Siaya Standing Orders. Madam Members, in line with the provisions of Standing Order 71-7, the County Assembly appointed a special committee comprising of 14 of its members, to investigate into the allegations made in the motion and report within 10 days on whether it finds the particulars of the allegations to have been substantiated or not. Honorable members, the members of the committee included Honorable members Francis Oteto, Oliver Rika, Andrew Mwende, Freddy Kumoro, Bernard Adala, Cynthia Kinyi, Seth Baraka, Silas Madingo, Eunice Achieng, John Apodo, Dorothy Inga, Justus Oguta, Julie Okello, and Michael Otieno. Honorable members, Standing Order 74(1)B on the right to be heard provides that wherever the Constitution, any written law, or one of these standing orders requires the House to hear a person on grounds of removal from office or in such similar circumstances, the House shall hear the person at the date and time to be determined by the Speaker for a duration of not more than 2 hours or such further time as the Speaker may in each case determine, and in such other manner and order as the Speaker shall in each case determine. Standing Order 74(2) further provides that the person being removed from office shall be availed with the report of the Select Committee, together with any other evidence adduced, and such notes or papers presented to the committee before the day scheduled for his appearance before the Assembly. Honorable members, the procedure that shall be adopted in processing this matter shall be as follows. The chambers. The speech or his defense shall not be followed by any question or comment, and the Assembly shall thereafter immediately proceed to debate and vote on the allegations found to have been substantiated. Honorable members, in the event that the Special Committee finds that the allegations against the Deputy Governor have not been substantiated, there shall be no further proceedings on this matter. I will give further guidance on how to proceed thereafter. The House stands guided. Next order.
Order number 3, messages.
Next order.
Order number 4, petitions.
Next order.
Order number 5, papers laid.
Chairman, the Special Committee.
Thank you, Mr. Speaker. Allow me to lay a table report of Special Committee investigating the removal from office of the Deputy Governor William Oduol by impeachment.
Honorable members, as I guided before, the report having been laid, the House stands suspended for about 5 minutes, and within that time you'll be able to peruse the report, then we resume. We'll be upstanding, honorable members, for the suspension. Okay. Hello, members. The supplementary order paper has been circulated and therefore wish to guide as follows. Firstly, is to welcome you back to the resumption of proceedings of this sitting. I believe that you have had an opportunity to go through the report of the Special Committee on the removal from office of the Deputy Governor, William Oduol. As you may have noticed, the committee has found the allegations of gross violation of the Constitution or any other law, abuse of office, to be substantiated. In particular, the committee found that on charge number 1 of gross violation of the Constitution and other laws, A, interference with the procurement process through acts of bid rigging, the special committee found the allegation was proved and therefore substantiated. Charge number 2, on abuse of office and gross misconduct, particulars being bulldozing officers to renovate the office of the Deputy Governor outside approved budgetary provisions. The committee found the allegation to have been proven and therefore substantiated. On misuse of public resources, the committee found the allegation was proved and therefore substantiated. On bullying, the committee found the allegation was proved and therefore substantiated. On misleading the public by giving false information, the special committee found the allegation was proved and therefore substantiated. Consequently, honorable members, the procedure to be followed in this case is as I had earlier.
And whereas pursuant to Standing Order number 71-7, the special committee investigated the matter and tabled its report today, Thursday, 8th May 2023. And whereas pursuant to Section 43 and 5B of the County Government Act and the Standing Order number 7110, the special committee has determined that A, on allegation of interference with procurement process through acts of bid rigging, the special committee found the allegation was proved and therefore substantiated. On the allegation of bulldozing officers to renovate the office of the Deputy Governor outside approved budget provisions, the committee found the allegations was proved and therefore substantiated. On the allegation of misuse of public resource, the special committee found the allegation was proved and therefore substantiated. This was contrary to provisions of Section 46 of the Anti-Corruption and Economic Crimes 2003, revised in 2016, which says that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. D, on the allegations of bullying, the committee found the allegations was proved and therefore substantiated. On the allegations of misleading the public by giving false information, the special committee found the allegations was proved and therefore substantiated. Now, therefore, pursuant to Article 181A and C, the Constitution of Kenya 2010, Section 33 of the County Government Act 2012, and Standing Orders 71 and 72 of the County Assembly of Siaya, Standing Orders, after according the Deputy Governor, Siaya County, William Oduol, an opportunity to be heard, the County Assembly resolved to impeach the Deputy Governor, Siaya County, William Oduol, on the ground of gross violation of the Constitution and other laws and abuse of office and gross misconduct. Thank you, Mr. Speaker. From the office by impeachment of William Oduol, the Deputy Governor, Siaya County. And whereas pursuant to Section 33 of the County Government Act 2012 and Standing Orders number 717 and 72, the County Assembly of Siaya, by a way of resolution on Monday, 29th May 2023, appointed special committee comprising of a third of the members to investigate the matter on proposed removal from office by impeachment, William Oduol, the Deputy Governor of Siaya County, and within 10 days to report to the Assembly on whether it finds the particulars of the allegations against the Deputy Governor to have been substantiated, and whereas pursuant to Standing Order number 717 and the special committee investigated the matter and tabled the report today, Thursday, 8th May 2023. And whereas pursuant to Section 43 and 5B of the County Government Act and Standing Order number 7110, the special committee has determined that A, on allegations on interference with procurement process through acts of bid rigging, the special committee found that the allegation was proved and therefore substantiated. On the allegations on bulldozing officers to renovate the office of the Deputy Governor outside the approved budgetary provisions, the committee found the allegations was proved and therefore substantiated. On the allegation of misuse of public resource, the special committee found the allegations was proved and therefore substantiated, and that this was contrary to the provision of Section 46 of Anti-Corruption and Economic Crime Act 203, revised on 2016, which said that a person who uses office to improperly confer benefit on himself or anyone else is guilty of an offense. On the allegations on bullying, the committee found the allegations was proved and therefore substantiated. On the allegation of misleading the public by giving false information, the special committee found the allegation was proved and therefore substantiated. And therefore, pursuant to Article 181A and C of the Constitution of Kenya 2010 and Section 33 of County Government Act 2012 and the Standing Order number 71 and 72 of County Government Act, County Assembly of Siaya Standing Orders, after according the Deputy Governor, Siaya County William Oduol, an opportunity to be heard, the County Assembly is begged to resolve to impeach the Deputy Governor of Siaya County, William Oduol, on the grounds of gross violation of Constitution and other laws, the abuse of office, and gross misconduct. Mr. Speaker, I know we have shared this particular report in most of the forums, our social media forums, within our website, and I hope a good number of us as members have also gone through it, and therefore I will not deliver much to go on the preface to look at some of this ground, but allow me, Mr. Speaker, to just move directly and say that when the committee was constituted, Mr. CA East Assembly gave a notice of motion seeking to remove the Deputy Governor, Mr. William Oduol, from office by impeachment. This is guided by the provisions of Article 181 of the Constitution of Kenya 2010, Section 331 and 9A of the County Government Act 2012, and Standing Order 71 and 72 of the County Assemblies of Siaya Standing Orders. In line with the Standing Order 71326, read together with Standing Order 72 and procedure adopted in processing the motion was as guided below, with the necessary modifications. A member who has obtained the approval of the Speaker to move a motion under paragraph 1 shall give a 7-day notice calling for impeachment of the Deputy Governor. Upon the expiry of 7 days after notice given, the motion shall be placed on the order paper and shall be disposed of within 3 days, provided that if the House is not then sitting, the Speaker shall summon the Assembly to meet on the and cause the motion to be considered at that meeting after notice has been given. Number 5, when the order for the motion is read, the Speaker shall refuse to allow the members to move the motion unless the Speaker is satisfied that the member is supported by at least a third of all members of the Assembly to move the motion. Provided that within 7 days' notice, the clerk shall cause to be prepared and deposited in his or her office a list of members of the Assembly with an open space given each member for the purpose of appending signatures, which shall be entitled signature in support of a motion for removal of Deputy Governor by impeachment. And further, the mover shall provide the Siaya standing orders. The motion was placed on the order paper for debate during a special sitting of the County Assembly held on 29 May 2023. In the motion, the mover stipulated the following, Mr. Speaker. In consideration of the provisions of Article 73(1)(a), 3 and 4 of the Constitution of Kenya 2010, herein referred to as the Constitution, insofar as it connotes to the manner in which the state officer is expected to exercise assigned authority, whereas Article 75(1) of the Constitution obligates a state officer to behave in all sense in a manner that is devoid of compromising public or official interest in favor of personal interest, aware that a state officer, having taken and subscribed to oath of office pursuant to provisions Article 7(4) of the Constitution, is duty-bound to adhere to values and principles of public service as espoused in Article 232 by the Constitution. Most importantly, the practice of equitable provision of services. Hitherto, the County Assembly of Siaya having signaled by public utterances and allegations by the Deputy Governor to the effect that there were misgivings, elements of moribund leadership, misappropriation of public funds, and biasness in budget allocation, among other depositions, the Assembly being fully appraised of the important provisions of Article 732D of the Constitution, which requires all state officers to be accountable to the public for their decisions, actions, and by implication, public utterances. The Assembly, in exercising its constitutional mandate of being bestowed with the powers to summon any person to appear before it for the purposes of giving evidence or providing information in line with Article 195 of the Constitution, resolved to invite the Deputy Governor to shed light into the import of his public proclamations about the administration in which he serves. Further aware of the significance of the provisions of Section 2(9) of Leadership and Integrity Act 2012, which prohibits an officer from knowingly giving false information to any person. Section 3(0) of Leadership and Integrity Act 2012, which prohibits a state officer from falsifying records or misrepresenting information, and Sections 273G of County Assembly's Powers and Privileges Act 2017, which clarifies willful furnishing of the County Assembly or a committee with the information which is false or misleading, or making a statement before a County Assembly or committee that is false or misleading, is the Governor. That goes against grains of several provisions of the Constitution of Kenya 2010, the County Government Act 2012, Leadership and Integrity Act 2012, Public Procurement and Asset Disposal Act 2015, Anti-Corruption and Economic Crime Act 2016, County Assembly's Power and Privileges Act 2017, and the Public Officers Ethics Act 2009. Mr. Speaker, the Assembly resolved to impeach the Siaya County Deputy Governor William Oduol under Section 3.3 of the County Governments Act 2012 and Section Standing Order 7.1 and 7.2 of the following grounds. Ground 1, gross violation of the Constitution and other laws. In that, we have 1, interference with the procurement processes through acts of bid rigging. Mr. Speaker, the Deputy Governor, William Oduol, interfered with the procurement of contractors for various road projects in the county and that of supply and delivery of certified seeds and fertilizer contrary to provisions of Section 47(1) of the Public Procurement and Asset Disposal Act 2015, which states that a procurement function shall be handled by procurement professionals whose qualifications are recognized in Kenya. B, the Deputy Governor coerced the head of County Procurement Unit to give him raw evaluation reports for the tender on supply and delivery of certified seeds and fertilizers, together with unsigned professional opinion, despite being advised on the danger of exposing such documents for a procurement process which had not yet resulted to final selection and award of tender. Mr. Speaker, the Deputy Governor, William Oduol, unjustifiably relying on the authority of the Office of Deputy Governor, caused to be changed by coercion certain specifications in 86 tender documents for road construction. By engaging in actions explained herein, Mr. William Oduol, being not a procurement professional, Mr. Speaker, with qualification recognized in Kenya, acted contrarious to the provisions of the procurement laws. Mr. Speaker, on ground 2, abuse of office and gross misconduct, bulldozing officers to renovate the office of the Deputy Governor outside approved budget. Mr. Speaker, the Deputy Governor, banking on authority of his office, forced incurring of an expense of approximately Kenya shillings 18 million for purpose of renovating his office, interior and exterior works, purchase of furniture and office equipment, an expenditure that was not in the budget and therefore not in the procurement plan. Mr. Speaker, this was in contravention of Section 53(2) of Public Procurement and Disposal Act 2015 of the procurement requirement. Mr. Speaker, I would say on the abuse of office, we have misuse of public resources. It is in record, Mr. Speaker, that on November 2022, the Deputy Governor William Oduol, while attending his PAC meeting in Sarova White Sand Hotel in Mombasa, in his personal capacity and not in his official capacity as a Deputy Governor, caused the County Department of Governance and Administration to facilitate him and 3 other officers whose relevance to ISPAC meeting could not be confirmed, as they were not members of the ISPAC, apart from the driver whose roles were undoubtedly essential. This was contrary to the provisions of Section 46 of Anti-Corruption and Economic Crime Act 2003, revised on 2016, which states that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. The Deputy Governor, therefore, Mr. Speaker, in his office, used his office to confer benefits to officers to attend a function that was irrelevant to them. Mr. Speaker, all the same, we have an offense of bullying committed by the Deputy Governor. In his efforts to coerce the County Director of Supply and Chain Management, Mr. Martin Okwata, to bend to his whims and change specification in certain tenders, the Deputy Governor, William Oduol, threatened the Director and promised him a harsh working environment in the coming future, apparently in reference to the Director's adamancy to give him tender documents. Mr. Speaker, it is also on record that the Deputy Governor demanded constant briefing from Director Supply Chain Management directly on matters procurement, despite Director not being answerable to him as per the structure of the county government service. The Deputy Governor demanded constant and repeated briefings, not only on matters of procurement, but also matters of finance. It was on record that he constantly and persistently demanded information on the county financial transactions directly from Acting Chief Officer for Finance and Economic Planning, Mr. Jack Odinga, despite the fact that Mr. Odinga was not directly answerable to him in his duties and responsibilities. This repeated behavior humiliated Mr. Odinga. It was peculiarly noted the Deputy Governor, William Oduol, only demanded direct and constant briefing from finance, repeated offensive behavior which is vindictive, cruel, malicious, or humiliating, and is intended to undermine a person. Mr. Speaker, the other offense presented here is misleading the public by giving false information. Moral and ethical requirement of a state officer dictates that he or she must always accurately and honestly represent information to the public. Mr. Speaker, the Section 29 of the Leaders on Integrity Act 2012 states that a state officer shall not knowingly give false or misleading information to any person. Section 272D of County Assembly Powers and Privileges Act 2017 clarifies as on of an offense action such as those which results in giving false information or evidence before Assembly Committee. Section 272G, Section 272F of the same Act further states that a person commits an offense when the person willfully furnishes a county assembly or a committee with information which is false or misleading, or makes a statement before a county assembly committee that is false and misleading. It is on record that the Deputy Governor, William Oduol, misled the county assembly and has continuously been misleading members of the public on the following instances, Mr. Speaker. One, that the Deputy Governor misled the public, the members of the public, that funds allocated towards completion of Siaya Stadium had been relocated in a supplementary budget 1 for the financial year 2022-2023. However, it was confirmed that the allocation had not been had been enhanced and not removed as the Deputy Governor claimed. Mr. Speaker, the Deputy Governor misled members of the public and the House that there was discriminatory budgetary allocation to disadvantaged residents of Alego Usonga constituency. It was later confirmed that Alego Usonga was the highest beneficiary of development funding in the supplementary budget 1 for financial year 2022-2023. The Deputy Governor misled the County Assembly and members of the public that the County Secretary, Mr. Joseph Ogutu, was forced to resign by the Governor, information that was denied by the County Secretary. Mr. Speaker, the Deputy Governor misled the County Assembly and the public that the county bursary allocation in Siaya is riddled with corruption, and that school head teachers who are critical stakeholders in the determination of needy cases are left out during vetting process. These are such given you, but there we have shown there that how we were established, and I did give the terms of reference on how we moved on with our investigations. And Mr. Speaker, allow me now to go to how we conducted ourselves as a committee to arrive at the decision we arrived at. In investigating this matter, Mr. Speaker, the committee undertook the following activities. During the first meeting of the committee held on 29th May 2023, the clerk of the County Assembly conducted an election of the chairperson and the vice chairperson, where Honorable Francis Utiato and Honorable Dorothy Oinga were respectively elected and opposed as the chairperson and vice chairperson of the committee. Mr. Speaker, the committee reviewed the particulars of the motion as was adopted by the House and identified relevant officers of the county executive department who would make submission before the committee on matters raised in the motion. In this regard, the committee resolved to invite the following officers whom it deemed relevant to submit information on allegations raised in the motion. Mr. Joseph Ogutu, the County Secretary, Mr. Benedict Omolo, CCM Finance, Dr. Edgar Upotumba, CCM Education Agenda, Mr. Agunda Ochanda, the CCM Governance, Mr. Joseph Omondi, the Chief Officer Governance, Mr. Jack Odinga, the Acting Chief Officer Finance, Mr. Martin Okwata, the Director for Supply Chain and Management, Mr. Dismas Dimanius Omolo, Administrative Officer, the DG's Office, Mr. Jared Abayo, Director of Public Participation, and Mr. Austin Otieno Gola, Social Welfare Officer. Mr. Speaker, the committee further invited the officers to appear before it on 6th June 2023. In our report is annex number 3 on the letters inviting the officers. The committee took cognizance of the provisions of Article 196 of the Constitution of Kenya 2010, which call for involvement of public in the process and activities of the County Assembly. The committee resolved that a notice for hearing be placed on the newspaper, which with nationwide circulation, the County Assembly website, and all official County Assembly social media platforms, calling for submission of memoranda, comments, and information on the removal of Mr. William Oduol from the office of the Deputy Governor. On 29th May 2023, a notice for hearing was placed on the official County Assembly to give information and evidence on the allegations on removal from office of the Deputy Governor and members of the public. The committee was scheduled to meet on 6th June 2023 to accord Deputy Governor an opportunity to be heard on all the allegations raised against him, and an opportunity to cross-examine persons testifying on a matter before the committee. A letter to this effect was delivered to the Deputy Governor, and in our report it is attached as Annexure 2. Submissions, Mr. Speaker. In light of the request for written submission extended to the officers and the Deputy Governor, the following officers presented submissions and documents in line with various allegations raised in the motion. Number one, on the allegation on interference with the procurement process, the committee received and considered written submission, documents, and oral testimonies under oath from Mr. Martin Okwata, Director of Supply Chain, who did a written submission and also was present here for oral submission. Then we had Mr. William Oduol, the Deputy Governor, who also did a written submission and an oral submission. On the allegations on the renovation of the office and office of the Deputy Governor, the committee received and considered documents presented, written and oral submission, and an oath from Joseph Omondi, the Chief Officer Governance, who did a written and oral submission, Mr. Jared Abayo, Director Procurement and the former Acting Chief Officer Governance, Director Public Participation and former Chief Officer, Acting Chief Officer Governance, Mr. Joseph Ogutu, County Secretary, who did oral submission, Mr. Martin Okwata, Director of Procurement, who did a written and oral submission, and then Mr. William Oduol, Deputy Governor, written and oral submission. On the allegations of misuse of public resource, and committee received and considered written and oral submissions under oath from Damianus Omolo, Administrator Office of the Deputy Governor. That was an oral submission. Mr. William Oduol, the Deputy Governor, who also gave oral and written submission. On allegation on bullying, the committee considered documents, written submission and oral submission under oath from Martin Okwata, Jack Odinga, and Honorable William Oduol. On the allegation of misleading members of the public, the committee considered to Mr. Benedict Omolo, Mr. Edgar Dr. Edgar Otumba, Mr. Agunda Ochanda, Mr. Joseph Omondi, Jack Odinga, Martin Okwata, Damianus Omolo, Jared Abayo, and Austin Ogola. At the hearing, the county assembly clerk read allegations against the Deputy Governor, verbatim, as documented in the motion for removal from office for the Deputy Governor, sponsored by Honorable Gordon Ongoro. And Mr. Speaker, while this was done, there were preliminary objections or preliminary issues that were raised by the Defense Counsel for the Deputy Governor. And in a written defense supplied to the committee on 5th June 2023, the Deputy Governor raised concerns touching on the process and the procedure for removal, procedure of removal from office of the Deputy Governor, and his concern was centered around 4 major issues. One, the Deputy Governor was questioning about the validity, procedure, and admissibility of the motion on removal from office of the Deputy Governor. Number 2, the Deputy Governor questioned the public participation process. Number 3, the Deputy Governor had issues with fair hearing. And finally, the Deputy Governor was seeking if there would be any other alternative other than the impeachment. During the hearing, the Deputy Governor, Counsel Paul Nyamudi, further raised concerns about the procedure adopted by the committee in line with standing orders. Mr. Speaker, on this matter, for us to proceed, we then had to sit back as a committee and look into those issues and came up with a resolution on the preliminary issues as follows. The committee analyzed the submission and evidence on the preliminary issues as raised by the defense and the deputy governor and determined as follows. 1. On the validity, procedure, and admissibility of the motion on his removal from office, the deputy governor averred that the motion before the special committee was defective and invalid for the purposes of founding the impeachment process and the proceedings against him, as it failed to meet Section 331 of the County Government Act and Standing Order 61 as read together with Standing Order 62 of the County Assembly Siaya Standing Orders. In response, the committee noted that 1, the mover of the motion was within the boundary 8 June 2023. In essence, the deputy governor jumped the gun in his submission. In short, Mr. Speaker, at this particular time, when the deputy governor came in, the learned counsel did ask that they were not provided with a report from the select committee, without knowing that what was sitting was the select committee, which had not made any report. They wanted to be supplied with the report 3 days before they appeared to the select committee. So we were asking them, how do you request or ask for a report on a select committee when appearing to the same select committee? So, Mr. Speaker, we really pitied the learned friend that he was not very much aware of the processes that happens in this House. On the matter on public participation, the deputy governor opined that the county assembly failed to sufficiently involve members of the public in processing the motion, as it only placed an advertisement notice in one of the daily newspaper and failed to utilize any other form of communication, such as social media and the website, to reach different categories of audiences. He further asserts that the advertisement notice placed by the county assembly calling on members of the public to submit their written memorandum and views was unreasonably short, and that there was no urgency whatsoever to justify the period of time given. In response, Mr. Speaker, the committee noted that the advertisement notice informing members of the public on motion for the removal of the office of the deputy governor, Mr. William Oduol, appeared on page 13 of Daily Nation newspaper on Tuesday, 30th May 2023. Mr. Speaker, the advertisement called on members of the public and relevant stakeholders to submit comments, information, and memoranda in relation to the matter. That the advert gave members of the public 7 days to present such information. Considering that the legally defined time frame for special committee to execute the matter is 10 days, Mr. Speaker, it was considered, after its constitution, it was considered view of the committee that the 7 days notice was sufficient. Mr. Speaker, on that, I know you realize that we are only having 10 days to execute this, and we decided to give 7 days for public participation, only remaining with 3 days to work as a committee. That the deputy governor was served with a letter dated 29th May 2023, notifying him of the motion seeking to remove him from office. Annexed to the letter was a motion containing detailed grounds as documented by the motion mover on the motion. In compliance with Article 47 and 50 of the Constitution of Kenya 2010, the notification served as invitation to the deputy governor to appear before this special committee on Tuesday, 6th June 2023, to respond to the allegations in the motion. The invitation clearly stated that the deputy governor had a right to appear before the special committee in person or through legal representation. The Deputy Governor further made request for documents and information to the Assembly which were adequately responded to and documents issued to him. Accordingly, the committee is persuaded that although the impeachment process has not reached the tail end, the Deputy Governor has so far been granted a fair hearing. On alternative remedy, the Deputy Governor stated that the County Assembly recourse to impeachment before exploring alternative remedies is evidence of bad faith. To this end, the committee noted that, 1, the removal from office of the Deputy Governor is a matter guided by Constitution and legal dictates, which provides for the procedure and the process. The law does not provide any other alternative procedure that ought to be followed in resolution of the issue before the committee. Mr. Speaker, consequently, the committee finds that issue of alternative remedy of the matter is not merited or guided by any provision of the law. Now, Mr. Speaker, allow me to proceed to committee findings on these issues. Interference and a gross violation of constitution and the law, the particulars of allegation number 1, interference with procurement process through acts of bid rigging. In the tender to supply and deliver certified seeds, number CGS SM AGR 1C OT, I know it's a long one. I will have maybe read it using our language on the other media, but allow it to be like that. You will read it. And that to supply and deliver fertilizer offered, even though the Deputy Governor indicated his dissatisfaction with the process, with the response. Apparently, there was a report in a weekly Citizen magazine about the tenders after they had been advertised. When this occurred, the Deputy Governor called Mr. Okwata once again to his office, reportedly to find out more about the tenders. When the subsequent procurement process were nearing completion, that is, a professional opinion was being prepared, the Deputy Governor summoned Mr. Okwata another time to his office. This time he asked to be given all documents relating to the 2 tender plus unsigned professional opinion. Mr. Okwata did not totally relent to the request, but gave him evaluation report and unsigned professional opinion. A few days later, EACC officers asked for documents relating to the tender, a request that was honored. The procurement was later terminated on material of governance grounds. I know maybe you will not find it written, but then for those who are present here who are watching it, you realize that for the purposes of even termination, the Director of Procurement talked about the time required for open tender to be longer, and because the rains were just ending, we needed a faster way of procuring, and therefore they had to terminate, not only for the governance issues, but because of also the period that was needed. In another incident, and around the same time, several tenders for roads constructions were being processed for advertisement. There was apparently a resolution by the Procurement Department, Roads and Public Works, to restrict the number of tender that could be bidded by a company having same directors and or by eligible contractors. This was part of the tender specifications. Before the tender were put up for advertisement, the Deputy Governor, in the same fashion, summoned Mr. Okwata and expressed his disenchantment with the clustering specifications. He reportedly pushed for changes in the specifications to allow one contractor to be awarded more than 2 contracts, and companies with same directors to be awarded more than 2 contracts. Mr. Okwata once more was adamant to effect the changes, arguing that the specification originated from at 2 a.m. So then we did ask Mr. Okwata, what were you doing at 2 a.m. for you to start sending emails at 2 a.m.? Then he said his life was in danger. He was threatened and could not sleep. At that time, every time he was dreaming of being chased out of job. So by that night, and again because he had to meet the deputy governor in the morning, he had just to do it so and have an evidence that actually he made that communication. Mr. Speaker, what did the Honorable Deputy Governor say? In his written submission to the committee, the Deputy Governor denied allegations that he interfered in the procurement process. He averred that the particulars to the tender were not disclosed to him, so he could not respond to the claim. In a statement submitted to the Assembly earlier on, signed by Deputy Governor, he had indicated that the procurement of seeds and fertilizer was suspect, that when the tender was put out, it had interesting eligibility criteria. He pronounced in the statement that he protested about the eligibility criteria, called Mr. Okwata to his office, but did not get satisfactory response. Further, in his oral submission made before the committee, he concurred with Mr. Okwata's statement that he summoned the same Okwata to his office, and the basis of the issue surrounding tender for seeds and fertilizer, on the basis of issues surrounding tender for seeds and fertilizer. According to the Deputy Governor, he only summoned Mr. Okwata after the article appeared in the Citizen Weekly newspaper, touching on alleged improprieties in the tender for seeds and fertilizer. He reasoned that he had been delegated the task of superintending on issue finance and economic planning by the governor, and was therefore within his obligation to call for clarification where it was necessary. The Deputy Governor informed the committee that his reason for summoning Director Supply Chain was his apprehension with the way seed and fertilizer was being procured, owing to the claim that he did not have a clue about the tender that was being referred to. And he also said in his oral submission that he only summoned Mr. Okwata after article about the tender appeared in the Citizen Weekly, a newspaper. The committee, meanwhile, observed the Deputy Governor contradicted himself by submitting in another statement that he summoned Mr. Okwata when the tender was put out. The Deputy Governor notably was mixed up as to when and why he called the Director Supply Chain Management. Mr. Okwata was consistent on the manner of involvement of the Deputy Governor in the procurement of seeds and fertilizer, and that he was asked to give a related document to the Deputy Governor. Mr. Speaker, the Deputy Governor was not contented with the procurement method used in tender to supply or deliver seeds and fertilizer. However, was not clear about the method that was on record in the procurement plan. The Deputy Governor had suspicions with eligibility requirements in the two tenders. It was therefore logical to adduce that he had access to the document and was well appraised of the contents therein. Going by the trail of communication between Mr. Okwata and Ben Oboge, and the CCM wrote Mr. Joe Nyinguro on the need to change specification on the road tender document, there was an attempt to change the specifications. The claim that the mail was not copied to the Deputy Governor does not exculpate the fact that there were records showing communication attempts to amend tender documents. The instance and the consistency of procurement officer and the CSCM roads and the public works circumventing a deputy governor's endeavor to cause a change and a change in the tender documents. Committee therefore conclude that there was a good resolve by framers of the procurement law to include provisions of confidentiality and to specify parties that can operate within such process. For instance, Section 441 of Public Procurement Act and Public Procurement and Disposal Act 2015 states that an accounting officer of a public entity shall primarily be responsible for ensuring that the public entity complies with the Act. Further, Section 67(1) states that during or after procurement proceedings and subject to subsection 3, no procurer, the Deputy Governor, Mr. Oduol, is not an accounting officer of a public entity. Neither is he a procurement professional whose qualifications are recognized in Kenya, and hence had no responsibility whatsoever in the procurement of seeds and fertilizer. The Deputy Governor, Mr. Oduol, undoubtedly gained access to procurement information. Yes.
Oh, thank you, Mr. Speaker. I know how the importance of motion is, Mr. Speaker. This is a motion of his own, Mr. Speaker, and I believe that, Mr. Speaker, time can also be considered, Mr. Speaker, because this motion, I think members are really longing, if possible, if they can debate over this motion, Mr. Speaker. How I wish, Mr. Speaker, if you can guide the mover, so that, because we have already the motion with us, Mr. Speaker, so if you can guide this House so that he can summarize, Mr. Speaker, because time is also very important. Thank you.
Yes, the Honorable Chair of the Special Committee, may you be guided that time is of essence and you don't have to read word by word. Just summarize within 10 to 20 minutes it should be done so that members can also contribute.
Thank you, Mr. Speaker. That is what I was waiting for, because I know when you give me that direction, I will easily move and not read verbatim. It is actually very tiring. Mr. Speaker, I conclude on the committee finding on the first charge, having stated that the attempts of a deputy governor, while he's not accounting officer, where he's not professional, amounts to interference. It's therefore that the charge against the deputy governor for interfering with the tender process is therefore substantiated. Mr. Speaker, I won't go into very inner details. I expect everybody to read on our second submission on abuse of office, where we said bulldozing of officers to renovate the office of the deputy governor outside the provisions of law. Mr. Speaker, On this particular, it was, I know we have the opportunity to read, where in the contravention of section 53(2) of the Public Procurement Act, it says that an accounting officer shall prepare annual plan and which, with the realistic format within the approved budget. But here you hear, Mr. Speaker, it is said that from our documentation that the budget in which renovation for the office of the Deputy Governor was done was outside the budget. At that time, Mr. Speaker, despite the evidence from Mr. Omondi, the chief of desk chair, seat fully sprang 1.12 million. Mr. Speaker, this is a seat, and as per the report, this is a seat that the Deputy Governor sits on. So we did ask him, Deputy Governor, you purchased seat worth 1.1 million for you to sit on. Then he said he was applied. But he said, how do you, this orthopedic, are you sick? That I have, and when you grow old, you need something to massage your back. That was it. So for sure, then we asked, you said you didn't know. How did they know that you are growing old and you need a massage on your back? And for sure, then it conveys the such irresponsible purchase should not be entertained by this House, and if at all no payment or any other budgetary requirement for it should be suspended, Mr. Speaker. Mr. Speaker, allegations of bullying. I'm just giving a highlight because now I expect everybody will go through it. On allegations of bullying, Mr. Speaker, one, Jack Odinga, did say, and because we have read here the definition of bullying. Jack Odinga was sitting here almost shedding tears when he was looking at the level of communication, and according to him, that as much as the immediate boss is the Deputy Governor, is the CEC Finance, and to him, he believed that any other communication between them had to pass through the immediate boss, which is the CEC Finance. And that in all this time, the Deputy Governor have always tried to avoid communicating with the CCM Finance and directly sending him mails to make some payments and to do all those other things without passing through immediate boss in order of communication channels. Mr. Speaker, and this was in relation to issue of pending bills, where Mr. Jack Odinga believed that Deputy Governor, being the chair of subcommittee on pending bills, ought to have taken back the report for adoption by the main committee, and therefore immediately the CECM Finance will pick it up to communicate with them. Finally, on the same from Jack Odinga, Mr. Speaker, the issue came here where Jack Odinga felt that by bullying here, constant communication from his senior, immediate boss, whom in a letter, it is written there that he should be briefing, his letter of appointment as acting finance, he was to be briefing Deputy Governor on some issues. But then on some of the issues of finance, Jack complains that when he wakes up and he finds his name being mentioned by his boss as a thief, a boss responsible to do disciplinary process, a boss who has never written to him complaining for anything, but he finds the boss calling him a thief, saying how he has sanctioned withdrawals of monies from different accounts. Jack did ask this House that in such matters of such kind of behaviors, so it was interesting that the department or the junior officers, they watched our Deputy Governor of his allowance for his faculty, assumingly. So, Mr. Speaker, on those without a proof, because we know when you are invited for any other public function, what ought to have happened is a proof of how that was relevant to us. So, Mr. Speaker, with that alone, we remain with the matter substantiated. Mr. Speaker, I'm going to the last one, which is going to take me only 5 minutes. Misleading public. On the issues misleading public, Mr. Speaker, okay, Mr. Speaker, on the issue of misleading the public, we had one, the Deputy Governor misled the members of the public that they are allocated, that funds allocated towards completion of Siaya Stadium had been relocated. We got an information here. He never denied it. He only said that he was misquoted, Mr. Speaker, but the CCM Finance was here and confirmed that there was no such allocation, even to Migwenas earlier. Discriminatory, like we have confirmed, the more monies were given to Alego than any other. So Alego was not discriminated in supplementary budget 1. Deputy Governor also talked about illegal Deputy Governor, and we urge this House, by that alone, without anything else, that false information is enough ground for us to impeach the deputy. I do ask Honorable Dorothy to second.
Dorothy, do you want to contribute later or now?
I'd love to contribute later, Mr. Speaker, but I second.
Okay. So, members, I will propose the question, but before I propose, I'm equally aware that the next session, before you start debate, the Deputy Governor should be in the House to respond to these allegations. So I direct the clerks to look for the Deputy Governor wherever he is within the presence, in case he is. Don't go to his home, don't go to his office. Just look for him within, because an invitation has been extended to him so that we don't waste time. Hello, members. Yes, members. Yes, Honorable Judy, I know you have a good tie, but just sit. As I propose, members, I will then propose the question, which is that whereas pursuant to Article 181 B and C of the Constitution of Kenya 2010 and Section 33 of the County Government Act 2012 and Standing Orders 71 and 72 of the County Assembly of Siaya Standing Orders, on Monday, the 29th of May 2023, this Honorable Assembly approved a motion proposing the removal from office by impeachment of William Oduol, the Deputy Governor of Siaya County. And whereas pursuant to Section 33 of the County Government Act 2012 and Standing Orders number 71, 7 and 72, the County Assembly of Siaya, by resolution on Monday, 29th of May 2023, appointed a special committee comprising a third of members to investigate the matter on the proposed removal from office by impeachment, William Oduol, Deputy Governor, Siaya County, and within 10 days to report to the Assembly on whether it finds the particulars of the allegations against the Deputy Governor to have been substantiated. And whereas pursuant to Standing Order number 71-7, the special committee investigated the matter and tabled its report today, Thursday, the 8th of May 2023. And whereas pursuant to Section 40, subsection 3 and 5B of the County Government Act and Standing Order number 7110, the special committee has determined that A, on the allegation of interference in procurement process through acts of bid rigging The special committee fund delegation was proved and therefore substantiated. On the allegation of bulldozing officers to renovate the office of the Deputy Governor outside approved budgetary provisions, the special committee found delegations to be proved and therefore substantiated. C, on the allegation of misuse of public resources, the special committee found the allegation was proved and therefore substantiated. On the allegation of bullying, the committee found the allegation was proved and therefore substantiated. On the allegation of misleading the public by giving false information, the special committee found the allegation was proved and therefore substantiated. Now, therefore, pursuant to Article 181A and C of the Constitution of Kenya 2010, Section 33 of the County Government Act 2012, and Standing Order 7 via email, an email address which was provided by himself during the interrogation or the hearing. And it reads, kindly receive the attached report as earlier alluded to. Kindly note the signed hard copy of all the attachments will be delivered to your office by tomorrow, 8 a.m. From our earlier communication, you will be expected to appear before the Assembly during its sitting scheduled for 8th of June 2023 at 2:30 p.m. Further, there was communication written to the Deputy Governor on the 7th, of course time not stated, and I'm reliably informed that this was sent to him via mail and also on WhatsApp. And it was reading as follows: the details, the reference being removal from office of the Deputy Governor, William Oduol, by impeachment. The sections, but of importance is this section which says, the tail end which says, in case the committee finds any allegations substantiated, you will be required to appear before the County Assembly during its afternoon sitting scheduled for 8th of June 2023 at 2:30 p.m. Remember, the earlier communication I read to you had forwarded to him the report, and in the report it was clear whether it was substantiated or not. His right of appearance or to be heard. And therefore, all we can do as a body is just to offer the opportunity for someone to be heard. Had they requested to be given more time, we would have considered that, but again, within the confines of the allocated time of 10 days. Honorable members, this day, the 8th of June 2023, being the 10th day from the day of constitution of our special committee, of course, without counting the 29th or the first day. This being the 10th day, we have no option but to proceed. I therefore direct that we proceed without necessarily listening to defense from the Deputy Governor. I therefore invite contributions. Honourable members, contributions. Yes, Honourable Oliver Rika, member for North Circle.
Okay, thank you, Mr. Speaker, and thank you for giving me the opportunity to air my views, Mr. Speaker. Mr. Speaker, first of all, I arise to support the report. And Mr. Speaker, I want to assure the good people of North Circle that the position I'm taking is for their best interest, Mr. Speaker. Secondly, Mr. Speaker, I would also want to congratulate and to commend the work of the special committee of which I was part of. They have done a good job, and actually we're just about to give direction towards that, Mr. Speaker. Mr. Speaker, I'm going to give a few opinion on the conduct of the Deputy Governor, Mr. Speaker. And I want to talk about specifically what has always disturbed me most is the withdrawal of 21 million, Mr. Speaker. And Mr. Speaker, I was scared and I was surprised that when the DG appeared before this house, that is 2 days ago, Mr. Speaker, surprisingly, the Fox was not able to explain the difference between a transfer and withdrawal. And Mr. Speaker, in response from the committee, the special committee, Adala wondered, Mr. Speaker. Mr. Speaker, the DG has always talked about the issues of corruption, Mr. Speaker. And actually it is confirmed, and it is now within the knowledge of the public, that the same person that has been making a lot of noise about the wastage of resources, Mr. Speaker, has been the culprit that we have been looking for. Because it is confirmed that 18 million, Mr. Speaker, was spent and was dispensed in the office of the DG in the name of renovation, Mr. Speaker. Currently, we know the status of the economy. We know how things are tough, particularly with the common mwananchi, Mr. Speaker. If this is the same person that has been crying all over that there is wastage of resources, that there is misuse of appropriate innocent individual is a night runner, Mr. Speaker. The assumption by the DG was that any money that is transferred from the IFMIS an Impress account is an amount that is prone to misuse, Mr. Speaker. I was really wondering, Mr. Speaker, why the DG would think that any money that is transferred from IFMIS to an Impress account would be prone to abuse. Then I started asking myself that could be that the DG was the night runner and Mr. Dinga was the innocent person here? Because how come he really believed that that money was going to be abused? Mr. Speaker, finally, I'm not so religious, but today you will allow me to quote the Bible, and I wish I'm going to quote the right one, Mr. Speaker. Mr. Speaker, if you read the Bible, there are common words that people use, like the word Jehovah Nisi, Jehovah Shalom, Jehovah Rapha. Mr. Speaker, it is always believed that these words refer to the name of God. The reality is that they are not. And for avoidance of doubt, Mr. Speaker, I would refer you to the book of Exodus, chapter 17, verses 50, Mr. Speaker. It is actually confirmed that the word Jehovah Nisi is the name of the altar and not the name of God, Mr. Speaker. Mr. Speaker, people will read the Bible